Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides our viewers the opportunity to call in and ask us any questions on any aspect of English law. On this show, I should be able to cover a vast diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your questions are, please feel free to ring on the number that appears at the bottom of the screen. Two ways to get in touch with us. There's the landline number 01924 231 083 and there's a mobile number. And if you want to send us a message, a WhatsApp message, a text message, please do so on the mobile number 07950797017. Now, as always, it's obviously a live show, so sometimes it transpires that callers who call in, their matters are quite complex and I need quite detailed information from the viewers who have called in. Or sometimes it transpires that I need to look at documents before I can advise further. For example, there may well be a letter that our viewer has received. It might be an immigration matter where they've received a decision and they need me to look at it before I can advise further. If it's the case that I need to have a thorough discussion with you or I need to look at your documents, then I will arrange for you to send your documents in, for you to speak to me off air, and we can have that more thorough discussion at that stage. And it is the free legal advice show. Any advice that I need to give you after I've looked at your documents or I've had a more thorough discussion with you is again absolutely free of charge and is part of the free legal advice show. So as always, the landline number that you can call on appears at the bottom of the screen and the mobile number is there for any messages that you want to send with your questions, your queries. The mobile number is a fantastic, easy way for you to get in touch with us. Sometimes legal matters are confidential. People don't necessarily want to come on air and discuss their legal matters live on air. If that's the case, a very easy way of getting in touch would be to simply send that message through to us on that mobile number. Now, we've already had a number of questions coming in. So let's look at some of the questions that have come in already. Okay, first question that's come in. Assalamu alaikum, says our viewer. I came into the United Kingdom on a spouse visa and my full 5 years have now been completed. I would like to apply for a settlement visa. What is the procedure? What application do I need to fill in? And is there a link to this as well? So, first question, it's about somebody who is in the United Kingdom on a spouse visa. So they've obviously got married to a UK citizen. They've come to the United Kingdom. They're in the United Kingdom on a spouse visa. And our viewer is asking that now that they've completed 5 years in the United Kingdom, what do they need to do? Now, obviously, the rules are basically that where somebody has been in the United Kingdom with a spouse visa for 5 years, they become eligible to apply for indefinite leave to remain in the United Kingdom. So as our viewers who've gone through this system will know, initially the Home Office will grant a 2.5-year visa. So a spouse who comes to the UK initially comes to the UK on a 2.5-year visa. After they've completed the initial 2.5 years, what then happens is that they apply for an extension of their spouse visa. And if that extension is granted, it's granted for 2.5 years. So that's what takes you to the 5-year mark. And once you've completed 5 years in the United Kingdom, you become eligible for indefinite leave to remain in the United Kingdom. Now, once you're eligible for indefinite leave to remain in the United Kingdom, there is obviously a process that needs to be followed. First question that's been asked is that what is the form that needs to be completed? Well, if you're doing the application yourself and you want to access the form, then you can do so on the government website. even if you were to go onto Google and enter SETM, which stands for Settlement Based on Marriage. So even if you were to enter the term SETM, you would come to the form which is used for a settlement application, where the basis of the settlement application is marriage. You're here on a spouse visa. So that bit is relatively easy. You access the SETM form online on the government website and you complete the application there. That's the correct form. So in one sense, that is a very easy. The process is quite reasonable. You complete that form. At the end, you make the payment that you're required to pay, which is approximately £2,400. With all applications, the next step is to book your biometrics enrollment appointment. You do that and the application is then processed. So in terms of the process that you need to follow, it is an online form, the SETM form, which you see through to the end. You make your payment, approximately £2,400, and then you proceed to booking the biometric enrollment appointment. So that's the process that you need to go through. Now, obviously that's the process, but there are certain requirements which need to be fulfilled. And I think the question that our viewer is asking is really in relation to the requirements which need to be fulfilled. The main requirement, as always, for these applications is, assuming you're both together, the parties are together, the main requirement always is the financial requirement. Generally speaking, with all applications, there is a requirement that the parties will be earning, either individually or jointly, they will be earning £18,600 per annum. So it could be that the husband is earning £10,000, the wife is earning £10,000. So combined, you reach the 18,600 mark. Or alternatively, it could be that it's just one party who works. It might be the wife who's working, it might be the husband who's working and earning above that threshold. So the financial requirement is one of the main issues. I'll look at the other issues after we've taken the next call for the day. Hello, Assalamu alaikum.
अस्सलाम वालेकुम सर, कैसे हो? ठीक है
जी अल्हम्दुलिल्लाह ठीक है, आप कैसे हो? ठीक हो?
मेरा क्वेश्चन है सर नेचुरलाइजेशन के बारे में.
जी ठीक.
I suppose let me ask the question and you can answer it.
Okay.
I suppose it takes 6 months, yeah. But my wife is applied it's more than 2 months. In what circumstances we can request the Home Office to process the application for naturalization? Can we do or not? That's what I'm asking. Thank you very much.
So you want to know whether you can request a quicker decision on the naturalization? So I think the question, okay. So I think the question is in relation to a naturalization application. Is there, as I was going to ask the caller some more questions, but I think what was being asked was whether we could get a quicker decision. Now, the general processing time used to be around 3 to 4 months. At the moment, you might be lucky if you get it processed in 3 to 4 months. One of the problems at the moment is this, that you submit the application, it's processed by the Home Office. So the Home Office has done their bit. After that, you need to attend the ceremony, the oath, where the oath is taken. The problem is you can't book a ceremony very quickly at the moment because some venues are closed, others are open, but there's a backlog, etc. So the problem, the delay seems to be really because not only does the Home Office have to process their application and they're a bit slow, but there's a difficulty in booking an appointment for the oath to be taken. So combined, there is a significant delay. So I think the caller is right. I think you have to work on the basis that the process will take approximately 6 months. How can you quicken the process? Well, there's two aspects to this, isn't there? One is the first part where the Home Office is dealing with the application. And the second part is when it goes over to the council for the ceremony where the oath is taken. In terms of the first part, now, generally speaking, it would be unusual for the Home Office to fast-track a nationality application. The reason for that is because if you're using an online a nationality application form, or even if you're using a paper form, you can always request your passport back, and it doesn't have an impact on your application. Your application continues to be processed. But if you are doing an online application, you retain your passports. If you've submitted a paper form, you can always request your passports back whilst the application is in process. Now, the point here is, because you've got your passports back, you're able to do most things. If you need to use your passport as an ID document, you've got it. If you need to travel, you've got it. So the problem is, there isn't normally a compelling reason for the Home Office to prioritize your application. I think there has to be a very compelling reason. It can't be travel, because you're going to get your passport back to travel. It can't be that you need your passport for ID purposes, because you can ask for your passports back. So generally speaking, when it comes to nationality, it's difficult to see what the compelling factor is which you can use to make the Home Office give you a quicker decision. So that's where the problem is. But let's say you do have compelling circumstances, then obviously you would write to the Home Office, inform them of the same, or alternatively, you would speak to your MP, give them the reference number, and ask them to make representations to the Home Office for a quicker decision. So that's the Home Office part. Once you've got a decision and you need to attend the ceremony, you could speak to the council. I think in my experience, they're more flexible. If you can demonstrate to them that there's a real reason why you need it processed quickly, it might be easier to convince the council for you to be able to have a private ceremony where the oath can be taken, as opposed to waiting for the group oath ceremony. So the key point here is there must be compelling circumstances as to why you need a decision made quickly. And if you do have those compelling circumstances, make your representations to the Home Office, and towards the latter part, make those applications to the council. Hopefully that will get you a more prompter decision on your application. Hope that answers the question. We're going to be taking a short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, 01924 231 083. Your call will be put through to me live on air, and I'll be able to speak to you and discuss with you any queries or concerns that you have on any aspect of English law. Alternatively, another popular way of getting in touch is to send me a message on the mobile number which appears at the bottom of the screen, 07950 797 017. Your question will come through to me live on air, and I will be able to address that live on air as well. Let's look at some of the questions that have been coming in today. Now, the next question that we've been asked on WhatsApp, it's been sent through on WhatsApp, is again in relation to a spouse application. And our viewer asks, I understand that normally you need to be earning £18,600 per annum in order to sponsor a spouse to come to the United Kingdom. Are there any exceptions to this, as I am not earning this amount of money? Are there any circumstances when you are exempt from the £18,600 requirement? Okay, a question that you come across regularly in practice, and it's to do with immigration spouse applications, where somebody is sponsoring a husband or wife to come to the United Kingdom. And as our viewers will be aware, people who follow this closely, people who've gone through this process, they will be aware that normally you need to be earning £18,600 per annum as a sponsor in the UK in order to sponsor a husband or wife to come to the United Kingdom. Now, what our viewer is asking is that whether there are any exceptions to this. Are there circumstances in which this £18,600 requirement does not apply? Now, there are some limited circumstances in which the £18,600 requirement does not apply. Generally speaking, that requirement won't apply where, in an initial spouse application, where the sponsor in the United Kingdom is in receipt of some kind of disability benefits or is a carer caring for somebody who is disabled. So, and I'll go through this in a bit of detail in order to answer the question that's been put to us. But in that situation, you can be exempt from the £18,600 requirement. So there is a way to get round the £18,600 requirement. Now, what kind of benefits will exempt you from the £18,600 requirement? Now, what I should say at the outset is, although these benefits are mainly related to somebody who's got disabilities or looking after somebody who has disabilities, the key point here is, in order to be exempt, it's not good enough to say, I am unwell, I've got a doctor's letter which confirms what my illness is, what my disabilities are. That's not what the Home Office looks at when you're looking at exemptions from the £18,600 rule. What the Home Office actually looks at is whether you are in receipt of these prescribed benefits or not. So what are these benefits which exempt you from the £18,600 requirement? The kind of benefits that you come across in practice are the normal disability benefits that somebody would get where they have moderate to severe disabilities. For example, it could be disability living allowance. It could be PIP, personal independence payments. It could be attendance allowance. So they're your normal disability benefits. There are some others that if you were getting, you would be exempt from the 18,600 requirement. So you must, in order to be exempt, you must be earning, you must be receiving one of these benefits. Now, if you're receiving one of these benefits, you're exempt. If you are caring for somebody who is disabled, and as a result of that, you are eligible for carer's allowance. So it's not sufficient that you're looking after somebody who is ill. That's not the test here. The requirement here is that you must be in receipt of carer's allowance. Again, it's a benefit administered by DWP. It has certain requirements which need to be fulfilled. But if you are fulfilling those requirements, if you are getting carer's allowance, then again, you would be exempt from the £18,600 requirement. So that's the real exemption. You're in receipt of certain disability benefits, or you're caring for somebody and you are in receipt of carer's allowance. Now, if you satisfy that test, it doesn't mean that's the end of it. You still need to be earning a certain amount of money. And I'll deal with that in greater detail after we've taken the next call. Hello, Assalamu alaikum.
Hello, walaikum salam.
Ji, brother, thank you for calling. Ji, bhai, what's your question?
Hello, I've got a quick question. It's regards to the nationality.
Okay.
I'll give you a summarized question. Is basically we've been granted for a discretionary release to remain during the old rules, which you follow like 6-year process, like 3 years.
Okay.
And after that, I believe you're eligible. Then I've got an indefinite leave to remain.
Sure.
And after that, basically 2 years or 1 year, you can eligible to apply for a nationality and stuff.
Yeah.
My question particularly, I've applied a nationality back in May 2020, and it's got refused, saying that
it'll be 10-year history.
Characters of
10
years. I think so. I would just because I didn't probably basically just forgot, like I have to complete 10 years, and it was like 1 month short because my application was
granted back in 2011 or something, June, and applied in 2020. It was like probably a 1 month different, I guess. So is that because I was assuming as soon as you complete your 6 years, then you can apply straight after 2 years of nationality. So,
it used to be the case that the Home Office wouldn't have taken an issue with that a few years ago, but now they do look at the 10-year history. So I think the issue really here is this, that, you know, when you were first granted discretionary leave back in 2011 or 12, they count your legal stay from that date when you were granted the first 3-year discretionary leave to remain visa. So when that was granted, I didn't quite catch whether it was 11 or 12, but whenever that was, they will count your legal stay from then. Because I'm assuming immediately prior to that, you were an overstayer. Is that correct?
Oh yeah, it was out of the basically discretionary leaves. Yeah, so that was correct.
Yeah, so this is the problem. So immediately before you're granted discretionary leave in 2011 or 12, you're an overstayer. So what they then do is, if you apply now, they go back 10 years. So even if you've got a couple of months where you've had a period of overstaying, they will say, oh, that's, as far as we're concerned, overstaying is, it falls within the bad character section, and therefore that's sufficient for a refusal on that point. They never used to be that strict, but bad character is now quite a big issue as far as the Home Office is concerned. So any period of overstaying generally in the last 10 years will result in a refusal. So when do you get your 10 clear years then in the United Kingdom?
Sorry, I'm afraid. What did you say?
When did you first get the discretionary leave? What date did you get that?
I think so. Exact date, not on top of my head. I guess it's back in 2011, okay. And from there on, so I believe now I'm well within my time, I guess.
Yeah. So as long as you've now cleared the 10 years there. So if, for example, if you got it in July 2011, then you just need to wait till next month, July 2021. So it just depends when you got it. Just make sure that you apply 1 day after you've got your 1 day after it was granted. So if it's granted on 20th of July 2011, you apply on the day after in 2021.
And I guess the later, in my case, I believe the later is better for me, I guess.
Yeah, just make sure we don't get the date. If you're not sure about when the initial discretionary leave was granted, if you're not sure, then you should make a subject access request to the Home Office and get your file. They will respond within a month, and you'll get to see in their file when the initial discretionary leave in 2011 was granted, and we just count that.
Oh, I appreciate it. Yeah, that's kind of good. Yeah, thanks for the support.
Just one other, no problem at all. Just one other point very quickly. You will need to pass your English test, your Life in the UK test, and your B1 test in English. You would have been.
I've done that. I've done that, all of them.
When did you do that?
Just last year, same time prior to.
Fantastic. It sounds good. It looks like this time it's going to be successful. Brilliant. Thank you very much. Thank you very much. Thank you very much.
Thanks for your help. Thank you.
Thank you.
Appreciate it. Right.
No problem at all. Thank you very much. Okay, let's take our next call. Hello, assalamu alaikum.
Wa alaikum salam.
Yeah, brother, thank you for calling. What's your question?
Hello?
Hello? You're live on air. What's your question?
My name is Mukhtar Ahmed.
Ji, Mukhtar bhai. Yep.
Can you hear me?
Yeah, I can hear you clearly. If you just speak up and tell me what your question is, you are live on air.
Okay. My problem is I worked for a restaurant.
Yeah, sorry. Yeah, sorry. If you carry on, you were saying?
Yes. I worked for a restaurant, and I worked like a cash in hand.
Okay.
Like I worked for 2 weeks for them, and after 2 weeks, they didn't pay my wages.
Okay, I understand.
Anything. Actually, I have no written contract or anything, just verbal contract I have with them.
Okay, I understand.
So what can I do legally to get my wages back?
I understand. It doesn't matter that it's cash in hand. You've worked, you're entitled to be paid. Couple of options, and I will look at this in detail after we come back. You can raise a grievance with the employer. They'll probably ignore you. You then contact ACAS. So there's an ACAS conciliation service that you must go through, early conciliation. So you contact ACAS, ACAS will contact the employer to try and find out what's going on. You need to do that within 3 months of you leaving your employment. So you contact ACAS, and even after you've contacted ACAS, if they don't pay you, you've got the option to go to the Employment Tribunal, and there are no fees payable for that. I'll look at this in greater detail after we come back from our break, but there are a couple of options open to you, so don't despair. We're taking a short break. We should be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live, please ring on the landline number that appears at the bottom of the screen, or by all means you can send me a message with your question on the mobile number that appears at the bottom of the screen. Just before we took our break, we had a caller calling in asking about an employment matter where he'd been working for 2 weeks, cash in hand, and not been paid. So as I advised, speak to the employer. Assuming you don't go get anywhere, you must then use the ACAS Early Conciliation Service. Go online, get to the right form, inform ACAS about what's happened. They will try and mediate. If that doesn't work, then you must issue proceedings in the Employment Tribunal. And normally that has to be done within 3 months of you leaving your employment. So there is a way of sorting it through ACAS and then ultimately through the tribunal. And you will obviously have proof that you've worked. You'll be able to explain to the tribunal what your circumstances are. So, assuming it's all correct, I think you've got a decent case and you should pursue this matter further. Thank you very much for that question. Let's take the next call for the day. Hello, Assalamu alaikum. Hello.
You've been placed on hold. Please wait.
I think we've got some difficulty in getting through to that caller. Sorry, you've had to wait a while. Please do call again with your question. Let's look at the next question that's coming on WhatsApp. The question is quite long. Let me read the question out and then let's look at what it says. It says, "Hi, I have a question. Okay. I am a British citizen, previously had refugee status in the United Kingdom. My mother is in Pakistan. She is nearly 75 years old. Nobody is available to look after her. She is in a care home. I want to see my mother, but due to threats that have been made to me, I cannot go to visit her. I haven't seen my mother for 15 years. I am a student at the moment. Is it possible for my mother to come to the United Kingdom?" A sad set of circumstances, to be quite honest. So our viewer who has sent the message in is a British citizen now, and it looks like the background to this is that the application for refugee status must have been successful, which then ultimately led to permanent residence, and then now our viewer has British citizenship. Now, understandably, reluctant to go back to their home country because of, as I understand it, I think threats which have been made against our viewer. Now, the problem is mother is in a care home, and obviously our viewer wants to visit or see whether there are any circumstances in which the mother can come to the UK. Now, realistically, there are only 2 options available to you. And even those 2 options are options which are difficult ones. So it won't be easy for your mother to get a visa under either of those 2 options. Now, the first option is that your mother comes to the United Kingdom as a visitor. And I'll look at that in greater detail. The second option is that your mother applies to come here under the adult dependent relative category. That's where people have elderly parents who are unwell, need to be looked after, and there's nobody to look after them in their home country. there are rules in place whereby you can sponsor an elderly relative to come to the United Kingdom. Extremely difficult to satisfy the requirements of that particular scheme. So they're the two options: visitor application for mother to come to the United Kingdom to visit you, or the adult dependent relative application, which actually leads to settlement. Both options are not easy options. It's easy for me to say, look, you know what, the immigration rules provides for this kind of situation. There are options open to you. Go for a visitor visa or go for a adult dependent relative visa. It's easy to say, but in practice, the requirements that need to be fulfilled for both are extremely difficult. The difficulty with the visitor route is this: that the Home Office will want to be satisfied, or the immigration officer will need to be satisfied, that your mother has an intention to go back to her home country. Now, the way that is looked at is to look at what the incentive is for your mother to go back. And that's where the difficulty is. We'll look at that in greater detail after we've taken our next call. Hello, Assalamu alaikum.
Hello, alaikum salam.
Ji, walaikum salam. Ji, thank you for calling. What's your question? Hello?
Hello?
Ji, hello, hi. I can hear you.
Yes.
If you tell me what your question is, then we can discuss that.
Actually, I like to know about the trust, how the trust works when you put a trust into the, because after your death, you want to put your property into trust, and
I think it's not very clear what you're saying, because it might be because you've got the television on in the background. If you could either turn the television down, move away a bit from the television set, it might be more clearer. So, sorry, I didn't quite catch what you said. Would you be able to just repeat that again?
Oh.
Hi.
Yes,
yeah, sure.
so that's because I do have a property and I got a children.
Okay, I understand. Yep.
But I have a really doubt that if I sell the house and give them the money,
Yep.
they will not use it in the right purpose way.
Okay, all right.
So therefore, I feel like if I put a property into trust,
I understand. Yep.
if they get any money every month as a distribute, or even the place like I want to do in the mosque and madrasas,
I understand. Yeah.
because I have quite a lot of properties,
Oh, I
almost
understand.
over £1 million.
Right. Okay.
So therefore, I don't want to, make into hassle into between them. Always also to have something I hope to put into the, Islamic way.
I understand.
So I like to know what will be the best and how does it work. I have no idea about it actually.
Okay. All right. Okay. Generally, you'd need to there may be tax implications here. I think that's the key
Can
thing.
I put the phone down now? And
Yeah, absolutely. Yeah, absolutely fine. Yeah, I'll take you through what happens.
Thank you.
Thank you very much indeed. So what our viewer is saying is that she has a number of properties valued in the region of approximately £1 million, wants to really sell the properties now, but is concerned that if the properties are sold and the money is given over to the children, they may use the money up straight away, and obviously, the money might go. So the idea that our viewer has is a good one, which is to put the money into a trust and for a certain amount of money to be distributed to the children on a monthly or yearly basis. So now, one of the first things that you do need to look at here is the tax implications, because to me it looks like obviously the properties that you would be looking to sell, it wouldn't be a residential property because you obviously want to continue living there. These are other investment properties that you have. Now, there may be tax implications when you come to sell that, so you will need to take advice. But what generally happens is this, that you have two options. You either create a trust, put the properties into the trust, and the rental income that comes out is then distributed. So you keep the properties go within the trust, and the rental income is distributed. Alternatively, the other option is what you looked at. You look at the possibility of selling the properties and the money that you get is placed into a trust, which again would normally be invested by the trust manager, and then whatever the profits are, they are then distributed as well. So you initially, I think, need to speak to a wills and probate lawyer, a trusts lawyer, somebody who can set up these trusts for you. So the trust would be independent of you, independent of the children as well, and it would have rules in place as to what would happen with any income, any money which is in there. So the trust would be independent, and you could really design it any way you want. But what you would need to do is really, when you do this, look at the tax position in terms of when you sell your properties, when the properties go into the trust, and when the profits from that is distributed. But normally probate lawyers would be able to set up a trust. I think the key thing is, at the moment, you need to look at whether you simply put the properties into the trust and you look at what happens to the rental income that you get, or, as you said, you sell the properties and you put the money into the trust. Obviously, you wouldn't normally leave the money there. You'd invest the money, and then you look at what would happen with the return that you get on that money which is invested. Or alternatively, you simply put the money into the trust, and every month, every year, a certain amount of money would be distributed. You could potentially set up whatever scheme you want. I think the key thing here is making sure that whatever scheme you set up is as tax efficient as possible. So you would need to look at the tax implications upon the sale, etc. You'd also need to look at the tax implications when the money is drawn out and it goes to your children. Some of them may not be working, so they've got a personal allowance that they can earn up to. Others may be working, which means whatever they get from the trust is income, which is taxable. So tax is normally a major issue when you're looking at these kind of assets. So the value is around the £1 million mark. But the reality is, if you speak to a probate lawyer, they should be able to set up something which works for you. It's really up to you as to how you do it, in terms of whether it's rental income they get, whether it's investment income they get, or whether it's just a certain amount of money that's gone into the trust, whether it's just distributed annually or monthly. So entirely up to you. That's all possible. But the best person to speak to would normally be a probate lawyer. And they may advise that maybe the best thing for you to do is maybe not distribute everything now. Make a will, and there may be distribution of some of the assets upon your death, so you can use the exemption that applies upon death. So that may be an option as well. A number of options here, a number of ways of doing it, but you need to explore all this with a probate lawyer. They will probably give you a better idea as to what your options are, because they specialize in these kind of matters. So interesting question. We're going to be taking a short break. We've had a number of questions coming in on WhatsApp as well. We'll be looking at that after we come back from our short break. We'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can ring on the landline number which appears at the bottom of the screen, or you can, as always, send me a message on WhatsApp or text message, which will be sent through to me live here, and I can answer the question that you've sent through by way of a message. Okay, we've had a number of messages coming in, but by all means, if you want to speak to me live, you can ring on the landline number that appears at the bottom of the screen. Let's look at the next question that's come in. Message from a viewer called Safraz. The question is this: I want to ask about my daughter who is turning 14 this year. She wasn't born in the United Kingdom, moved here at the age of 1. Me and my partner aren't from here either, but I wanted to know whether she can apply for nationality or indefinite leave to remain. Interesting question. We don't have a lot of the background information here, but let's look at what we've been told. daughter who's turning 14 this year, wasn't born here, came to the UK when she was 1. Parents don't have British nationality. Can the daughter apply for nationality or indefinite leave to remain? Slight difficulty here is this. If the daughter had been born in the UK, there is a specific rule whereby child born in the UK who lives in the UK for 10 years would be eligible for British nationality at the age of 10. But that only applies where the child was born in the UK and then lives in the UK for 10 years. Here the problem is the child isn't born in the UK. So we can't use that either. Now, the problem then is this. If you can't come within the nationality rules, you've got to look at the normal immigration rules. Now, a child who is under the age of 18, like the daughter here, who's now lived in the UK for 13 years, wouldn't be eligible for indefinite leave to remain. They would be eligible for leave to remain. And once they get their leave to remain, they are placed on the 10-year track to indefinite leave to remain. So they would have to continue to apply for an extension of their visa every 2.5 years. So if she applies now for leave to remain under the immigration rules, and this is on the basis that she's overstayed. And I'll come back to what the position is where somebody hasn't overstayed. But assuming she has overstayed, and this is where the problem is, I don't think we have enough information here. But let's say the family has overstayed, she's overstayed. Then at the age of 14, she would now be eligible, having lived in the UK for 13 years, to apply for leave to remain. So after 10 years, she gets indefinite leave to remain. And then after 1 year after that, she would be eligible for British nationality. That's where her circumstances at the moment are that of her being an overstayer. If, on the other hand, she came here when she was 1, she's 14 years old now, she has lived in the UK legally for 10 years, so it's 10 years legal residence has already passed, then she would be eligible to apply for indefinite leave to remain. So nationality is really out of the picture here at this stage. What we're looking at really is whether her residence has been unlawful or whether it's been legal residence. If it's unlawful residence, she applies for a visa now under the 10-year route. If it's the case that she's spent 10 years in the United Kingdom lawfully, then she would be eligible to apply for indefinite leave to remain under the 10-year long residence rule. So the distinction is between unlawful residence, where somebody's overstayed, and lawful residence. Unlawful residence, you start the 10-year process now. If your residence has been lawful, you're eligible for indefinite leave to remain based on 10 years residence. Let's follow this through. 10 years in the United Kingdom, you've qualified for legal residence in the United Kingdom, you now qualify for indefinite leave to remain. The next question is this: a child who has indefinite leave to remain, is the child eligible for nationality where neither parent has nationality? Now, my understanding is that the Home Office will refuse the application. Normally for children, what the Home Office want to see is one of the parents has nationality at the very least, and the other parent has indefinite leave to remain, or it's obvious from the circumstances that the other parent's life is going to be based in the UK going forward. So with a child, when you look at nationality for a child, you look at the parent's situation. Do they have nationality? Does the other parent have indefinite leave to remain? Now, assuming that both parents do not have nationality, I think the child might be in some difficulty in obtaining nationality at this stage. However, at the age of 18, the child would be able to apply as an adult in her own right when she turns 18. So she'd be somebody who has indefinite leave to remain. somebody who's been legal in the UK for a number of years, more than 10 years, somebody who's held indefinite leave to remain for more than a year. So as an adult, she would qualify for nationality at the age of 18. So here, we've got basic details here, but here, there are a number of factors that you need to consider. One is, I think we need to rule out nationality. We need to look at whether it's lawful residence or unlawful residence over the last 13 years. We then need to look at eligibility for indefinite leave to remain. And then ultimately, once the daughter has indefinite leave to remain, it looks like she may be unlikely to qualify for nationality based on her own status, because the parents don't have nationality. It may be that she needs to wait until she's 18. Hope that answers the question. The answer was a bit general because we didn't have enough information. If you feel that I haven't answered your question properly and there's some other relevant circumstances that you want me to look at, by all means, please do either text in or give me a call on the landline number, and I will go through this in greater detail. So I've tried to cover a number of scenarios here based on the information that you sent through. But Safraz, thank you very much for that question. What a very interesting question that you sent through. Okay, let's go back to the question that I was answering, which I then stopped dealing with because I think we had a caller that called in, which relates to our viewer who's got refugee status in the United Kingdom and then ultimately, based on the refugee status, qualified for British citizenship, has a mother who's abroad, mother is in a care home. Viewer is looking at how he can get his mum to the United Kingdom. And I said the options were quite limited. There were two options, both easy sounding options, but in practice, both have complications. One is that mother could come to the United Kingdom as a visitor. The other option is that she could come to the United Kingdom under the adult dependent relative category. Both are difficult. Now, looking at the visitor category, the difficulty is this. With the visitor category, what the Home Office looks at, what the immigration officer looks at is whether the applicant, the mother in this case, has the intention to return home or not. When the immigration officer looks at this question, whether a mother has the intention to return home or not, what the immigration officer tends to do is look at what incentive does she have to return to her home country. So the factors that they take into account are like this. What's the applicant's financial circumstances like in their home country? Are they well off? Do they have a good income? Is the applicant in good employment, stable employment? Does the applicant have a lot of savings? Does the applicant have a partner in their home country? Does the applicant have children under the age of 18 who are dependent on the applicant in their home country? So a whole host of factors are looked at to assess whether somebody has the incentive to return to their home country or not. The idea is this: if you live in comfortable circumstances in your home country, you've got a good job, good money coming in, good savings, have a partner and children that are dependent on you, then the point that the Home Office makes is that you are likely to go back. Contrast that with the unfortunate situation we have at the moment. Mother is in a care home. It may well be that financially she's not well off. Obviously, it sounds like the children have now all grown up. We don't know where the partner is. Indeed, that father may not be with us anymore. So the circumstances, unfortunately, are such that when the immigration officer is assessing the application, he or she may take the view that there isn't much that will make this person go back. Once the person is here, they are likely to stay with their son, on whom they will rely, who they may be relying on at this stage anyway, financially. So it's because of that, the visitor application, which is there to cater for these situations, allow people to come here and go back, it becomes difficult. So visitor applications are difficult. The problem with the adult dependent relative category is this, that you will only qualify under that category if your relative, mother here, needs personal care. She obviously does. She's in a care home. That bit we satisfy. But it's the second bit of the requirement, which is that even if you can pay for personal care, it is not available. Now, it's obvious from the question that mother is being provided with care. She is in a care home at the moment. So the problem is with the second bit. She has access to care at the moment. And where the applicant has access to personal care in their home country, they can afford to pay for it, the sponsors here who can pay for it, where that personal care is available, affordable, then that in itself is a reason to refuse the adult dependent relative application. That's where the problem is with this particular scenario, that even if we say we want to call her here, care for her here, the Home Office's position is she can be cared for in her home country. The facilities are there. So they're your two options. They're not great options. Visitor on the one hand, the adult dependent relative on the other. Both very, very difficult. Unfortunately, that brings us to the end of the show. Hopefully, we'll be back next week on Tuesday at 8 o'clock. Inshallah, see you then.